that the clear purposes of the organisation were to produce surpluses for charitable endeavour. Now, both the Productivity Commission and Dr. Henry have said that not-for-profits ought not to be limited in commercial activity. That is confirmed by the High Court's decision. The Honourable Treasurer, now Deputy Prime Minister, wrote to the community housing sector in New South Wales earlier this year, saying that Word Investments provides a structuring opportunity for the not-for-profit sector to legitimately run commercial activity to advance their charitable objects. So we've got all of this public policy saying that the charitable sector ought to be able to do this, and then we have the gatekeeper trying to really narrow who can take it, what participants within the charitable sector may access that window of opportunity that the charitable sector has to use commercial activity as a way of supplementing its need for income. As the volunteer base diminishes, the sector needs to find other ways of raising funds.
Do you have concerns, though, in terms of the public policy aspects of that if an organisation is operating, say, a charity is operating a printing business, they can compete unfairly with a commercial printing business that doesn't have the benefit of a tax-free status?
I don't have those concerns. I note with interest what the Productivity Commission and Dr. Henry had to say about competitive neutrality, and that against that litmus test, that there was no reason as to why the charitable sector ought not to be able to access the tax concessions they do, and that it had very little adverse impact at a consumer level.
Because they're charity.
Although, if it grew, so I mean, there could be instances where a commercial offshoot of a charitable organisation could be so big that it could distort the market and drive those businesses, those commercial businesses out of the market. That could be the case.
Yes, that could be the case, but I think that there would be legitimate sanctions under the trade practices and fair trading regimes that could prevent that from occurring. I haven't directed my mind at length to that.
No.
We're not. It's a fair question. I don't think we're in that space in relation to any commercial activity, so far as I'm aware of of not-for-profits that have charitable tax status.
You acknowledge there's a potential there for that if it could.
Yes, there is.
Yes, sure. Can I just ask? Earlier in your evidence, you talked about how the tax exemptions, for organisations that deliver a common good outcome, and if they don't do it, then the government would have to pick up the tab. I think that's sort of trying to summarise your position.
Yep.
To what extent do you think it's important that either the ATO, under the current rules or under any changed circumstances, ought to look at the proportionality of it? In other words, if an organisation takes in $1 million in donations or in revenue, but only spends $1,000, to give an extreme example, on charitable purposes, should that be a factor to be taken into account in determining whether it's reasonable for that organisation to have a tax-free status?
Oh, absolutely, and it's currently a status. It's currently a factor that an organisation, to maintain its tax-exempt endorsements now, must, not just as a matter of purpose, but activity, the dominant activity must be charitable. To the extent that the dominant activity is not charitable, their endorsement status is at risk. So I think any codification would equally take that into account.
So proportionality is not unreasonable. And what about the whole issue of transparency? Do you think that's important? You see
absolutely. I agree wholeheartedly with transparency. The UK Charities Commission has done some excellent things on its website about transparency.
As has the New Zealand Commission.
Absolutely.
Yes. Thank you, Chair.
Thank you, Senator Xenophon. Senator Fisher has questions. Oh, Chair, thank you. Mr. Lind, do you advise unions and employer organisations?
Personally, no. One of my other business partners in our firm may have, but no.
So you don't, you wouldn't be able
Not
to-
as a matter of everyday practice.
Point of order.
Yes.
This is the second time that Senator Fisher has come in and done what she normally does, and that is attack the trade union movement. This is not about the trade union movement. The trade union movement is not a charity, and unless there's a link to the trade union movement and this inquiry in relation to charities, these questions should be ruled out of order.
Chair, given that the witness is
I'm
not
asking for a ruling. I'm not asking to
experienced
hear from Senator
in
Fisher.
advising unions and employer organisations, I would not proceed with my questioning of him for that reason. I'm not accepting Senator Cameron's points at all, but I wouldn't proceed given that the witness is not equipped, I don't think, to explore the issues. Thank you, Mr. Lind.
Thank you. In that case, we thank you for appearing, Mr. Lind. There are no further questions. The committee will resume at 2 o'clock.